You may recall that after the president declared state of emergency in Rivers State, he appointed a sole administrator that will be piloting the affairs of the state for 6 months. He also went forward to note that they will be submitting the name of the sole administrator that was appointed and the declaration to the National Assembly for ramification and rectification. However, against this established protocol, the president hurriedly went ahead to swear in the sole administrator even without the National Assembly's approval. Nigerians are not asking why was he in haste to swear in the sole administrator? Why the hurry? Listen to this argument and share your thoughts.
The Nigeria Bar Association, for instance, says the emergency declaration doesn't automatically dissolve or suspend elected state governments, asking the National Assembly to reject any unconstitutional attempt to ratify the suspension of Siminalayi Fubara as governor of Rivers State. It said President Bola Tinubu's suspension of Governor Fubara is illegal and a dangerous affront to the country's democracy. The association, in a statement by its president, Afamusigwe, said the law body is gravely concerned by the development, adding that such actions amount to an unconstitutional usurpation of power and a fundamental breach of Nigeria's federal structure. It adds that the 1999 Constitution doesn't grant the president powers to remove an elected governor, deputy governor, or members of a state's legislature under the guise of a state of emergency. Let's bring in lawyer Ogunye, who joins us again on the program today. Also joining me is Ivan Sofili, who's also a lawyer. Gentlemen, thanks for joining us on the program this hour.
My pleasure.
Good evening. Thanks for inviting me to the program.
Good evening. Let's begin with Mr. Ofili. Quite a number of questions on the mind of people. What is the limit of Section 305? Who interprets this? Is the president constitutionally empowered to suspend democratically elected officials, especially now that the NBA has taken a stance on that? How do you react to this, Mr. Ofili?
Well, the president is constitutionally empowered to make a declaration of a state of emergency, a situation where you have clear and present danger, where there is maybe mutiny, there is political crisis that has engulfed the nation, and in order to preserve, and restore peace, Section 305 empowers the president to make a declaration of state of emergency, which is critical, which the president did. But where he got it wrong is where he suspended the State House of Assembly of Rivers State and the governor of Rivers State and his deputy. You know, the essence of a state of emergency is actually to restore peace. And it's not in all situations that it has to do with political crisis. There are times when it has to do with maybe outbreak of disease, pandemic, pestilence. In that Section 305, you will see all the grounds, even war, okay? In which case, a declaration of state of emergency will not in any way terminate the office of the governor of the state or the State House of Assembly of the state. So I think that if the essence of a state of emergency is to quell a problem or to bring a dispute to some level of halt, then it should be targeted at that. In the case under reference, the president could have as well intercept those who have blown up pipelines, because that's the reason now, the underlying reason now they're giving for that, for suspending the for suspending the governor and the State House of Assembly and the deputy. The president ought to have, move in and take care of the situation, the crisis.
All right.
Because that is the limit of his powers under the law. He's not empowered to suspend a democratically elected governor. The areas through which a governor can be removed from office are very clear. Okay, through impeachment by Section 198, by death, by resignation, and by incapacitation. Okay, so there is nowhere in our entire law that you can remove someone who is democratically elected in this manner, because the president have no such powers under our laws.
I hear you, Mr. Philip. Let me bring in Mr. Ogunye. We were speaking yesterday, and you also emphasized the need for the president's involvement. Only this time is enacted a state of emergency. Twice we've had Mr. President during the national broadcast fingering the state governor for not doing anything following the explosion of pipelines. The Attorney General also made allusion to that during his press briefing today. What do you make of Section 305? Is the president backed by law to suspend the governor, his deputy, and members of House of Assembly?
Now, the way I answer that question, I am aware that a number of lawyers in Nigeria, including the Nigerian Bar Association, have contested the power of the president to suspend a governor and members of the House of Assembly while declaring a state of emergency. In all these public declarations or pontifications or enlightenment, as the case may be, nobody has been able to cite a precedent in Nigeria by which a court of law positively and categorically declared that kind of action by previous presidents or prime minister to be illegal and unconstitutional. I'm a lawyer. Lawyer live by and they practice by precedents and decided cases.
What was the position of the Supreme Court in the case of Plateau and Ekiti State?
We'll get to that in a moment. And so, what has occurred lightly will be regarded as enlightened opinion. I won't say guesses, enlightened opinions on what the issues are. However, some of the declarations are exaggerated because I know, taking this matter very broadly and deeply, that in certain cases, removal of a governor or suspension of a governor is not even excluded. For example, if a House of Assembly were to pass a resolution seceding from the country, and the governor of that state were to embark on steps to implement that resolution. So if a state of emergency is declared from the center, as it has been declared now, would anybody then be contesting the power of a president or a National Assembly to not only remove those governors during that period, but also to charge them with treason or treasonable felony at the very least? I mean, nobody will be contesting that. So it's not in all situations. People are speaking too affirmatively when there is no guidance, case law guidance on the subject. Historically, in this country, declaration of a state of emergency on a political crisis, quote unquote, has always come with these kinds of suspension. In 1962, it happened in Western region when Chief Ladoke Akintola, who was resisting a vote on the floor of the Western Regional House of Assembly to determine whether he had lost confidence or whether he lost confidence or not, and who was recalcitrant, was then removed from office. There was a Coca Commission of Inquiry, right. And later on, he was returned to power. On that occasion, there were cases that were sent to court. Williams and Majekodun, Adegbenro Akitola, and so on and so forth. And those cases were not resolved in favor of non-removal or non-suspension. Under the 1999 Constitution, we've had two occasions in which this had occurred. In Plateau State, Chris Ali became an administrator in Ekiti State. Oluri Tunji Olori. Both of them now, late, became the state administrator. And when the matter then came up to the Supreme Court, in the case you cited, Plateau State government, and then the House of Assembly of Plateau State on one side, and the Attorney General of the Federation, a case that was reported in 2006, 3 Nigerian Weekly Law Reports, at 967, I think at page 346, a preliminary point was taken. The doyen of constitutional law in Nigeria, Professor Ben Wabezi, God rest his soul, was representing the Plateau State government. And the preliminary point that was taken in that case was whether that action was properly brought. Those who brought the action were those who had been suspended. And the court simply said, on the fact you had been suspended. So at the time you instituted this action, the alter ego of government in that state is the sole administrator. And the sole administrator came to court and deposed an affidavit saying he didn't instruct anybody to institute such a case. So local standing wise, legal wicket wise, authorization wise, the case was thrown out of court. And the substantive issue of whether the suspension of the House of Assembly of the governor, was constitutional or not, that substantive issue was not taken. A lot of jurists, lawyers have said that the Supreme Court conveniently dodged discussing that issue. So if you go by that precedent, what that will imply, for example, is that if Fubara or Amaewhule and co were to go to court to challenge that in the name of the Rivers State government, the Supreme Court will shut its door against them and say that you cannot come to court. So the point I'm making is that while there is nothing under Section 305 that clearly permits a president to take this step, and why I have very deep-seated reservation about the central government, dissolving the government of a subnational government, there is no case law precedent prohibiting that conduct as we speak. So all of us are then left with our own opinions, quality as I am expressing mine.
I hear you clearly, Mr. Ogunye. The big question has always been whether or not democratic principles were followed in terms of interpretation of that section and the actions taken by Mr. President, and if there are outright regards for democratic rules and principles, especially considering the fact that, considering the progress we've made democratically, and then having to revert to a sole administrator gives its reminiscence of military rule. And some are saying, have we really recovered from hangover from military days? But I want us to explore a few other questions on the mind of Nigerians. Mr. Philly, if you are still there, Mr. President talked about the limits of the administrator's powers, that he can't make new laws, but he can come up with regulations. We hear now that allocation has now been, Riverside allocation has now been released, or is now being released to him. But then these regulations we're hearing are subject to approval by the Federal Executive Council, which has raised another question whether or not FEC has the constitutional right to do that as against what should be the responsibility of the National Assembly. What do you make of this?
Well, that is to further entrench the illegality I was talking about. Granted, there is no case law whatsoever on the issue under reference, but there is, we have a judicial authority, we have the Constitution, we have statute, and the statute under reference did not in any way give the president that power. So the National Assembly's concurrence that is required, I don't know how they went about that before this swearing in, whether the National Assembly, they said they were going to do that by 3 o'clock today. Whether or not they've done that, I wouldn't know, but the swearing in of the sole administrator are taking place already.
I don't think they did. They
And
adjourned
now,
till, the Senate adjourned till 11 a.m. tomorrow. But according to that constitutional provision, I think they have 48 hours. So it still can be done tomorrow, right?
yeah, they have 2 days. So why do you swear in? I mean, this is all whole illegality. Because the man has resumed office and the National Assembly concurrence have not been taken to that effect. Okay, so now it's going to be answerable to, the presidency as it were, or FEC as it were. Okay, so under what law? Under what law are we manufacturing all this? And this is so painful because you have an Attorney General of the Federation who is supposed to guide the president aright on the issue under reference, but he's not doing that. Rather, with due respect to him, there was a press conference where I heard him defend, what is going on, and I feel that that is not the law that we're taught. I beg to disagree that where you can't read into the law what is not there. The express mention of one thing excludes the other. Okay, as much as the Supreme Court have not given any directive or direct pronouncement on the issue under reference, does not mean that we are helpless. The law is still there. That's the Constitution, and that's the ground norm. The ground norm for which even case law are subject to. You understand? So what is wrong by all stretch of imagination.
But in that regard, Mr. Philly, I think that 305 is quite clear as to what happens next. 48 hours if the National Assembly is in session, 10 days if they are not. We don't expect there to be a vacuum if that decision has been gazetted. The decision lies in the hands of the National Assembly. It's either they ratify it or veto it. If they do veto it, that means the decision by Mr. President ceases to be recognized as lawful. Let me bring in Mr. Ogunye quickly. We are waiting to see the direction or decision that the National Assembly will take on this matter. Quite a number of your colleagues have called for them to listen to the people that they represent and, vote according to what they desire. What that means really, personally, I don't know. But do you think the suspended governor of Rivers State is still protected by the immunity clause of 1999 Constitution, which protects him against police arrest or prosecution in court? Where do we stand with that as we speak?
Now, there's a case law precedent, which we can cite for guidance. Some of these things just happen and they are not settled yet. DSP Alemesea, during his moment of trial, encountered a question like this during his travel in those days. And he went to court and he obtained an order against the ICPC to the effect that he should not be arrested or investigated, that he still had immunity protecting him, regardless of the fact that he was temporarily removed from government, by that impeachment or state of emergency by Bayelsa State at that time and all that. So if you look at that, you can say that a suspended governor still remain a governor, during his tenure, and therefore still has an immunity cover. But, I don't know what will happen if this position were to be tested in the court tomorrow. But let me just say generally that there has been a number of missteps, and I agree with my learned friend there. It appears to me that Mr. President is fast-tracking these steps for political reasons, to be able, in my view, to muster sufficient support for a declaration of state of emergency. Otherwise, the swearing of the sole administrator can wait until after the proclamation is voted upon by the National Assembly. Now, it's given under the provision of the Constitution, Section 305, that if the National Assembly votes against the proclamation and doesn't approve of the proclamation, that ends the matter. It is also worthy of note that when a state of emergency is proclaimed, as it's been proclaimed by the president, the National Assembly is empowered to set the terms. Indeed, usually the National Assembly legislates by coming up with emergency powers regulations or something to that effect, prescribing how that emergency powers will be exercised. They did it during the 2013 declaration of the state of emergency by President Goodluck Jonathan, when those states in the Northeast had a state of emergency being declared in those states and all that. I know that yesterday in the proclamation speech, the president hinted that the regulations to be made by the sole administrator will be subject to the ratification of the Federal Executive Council. And people have said that no, the president and his Federal Executive Council lack such powers. But today, I've just spied out a bill that was said to have been passed, and I'm still saying that I will have to research the subject, whether that bill actually translated to an act of the National Assembly and is being codified. It's called the Emergency Powers Act, and this is important. Emergency Powers Act, passed in 2018. And I think that the commentators should try to find out the status of that act.
Mr. Ogunye, we have completely run out of time. We have to go now. But I'm sure that this is a developing story, and we have you to get back to in time to continue this conversation. Ivan Sofili, live for us from the U.S. Dito Ogunye is here in Lagos. Gentlemen, thank you so much for joining us on the program this hour. The ball is now in the court of the National Assembly. Whether or not they will ratify Mr. President or veto him, the time is ticking. And I guess by tomorrow we should know what that decision is. But thank you again, gentlemen, for joining us.
My pleasure.